Formalities for making certain types of trust are covered in the Law of Property Act. I think it's 1925. Yeah, Law of Property Act 1925, and in section 53. What you'll see in the subject guide is that the tutors in the subject guide use the words procedural versus substantive as a way to analyse how the different sections of section 53 operate, or the different clauses of section 53 operate. And you'll have come across this idea of procedural versus substantive before now, probably in jurisprudence most likely. You might remember procedural versus substantive ideas for the rule of law, where some thinkers think it's purely procedural, in that to meet the rule of law, the way that the law is made and conducted has to have certain steps. So it has to apply to everybody, it has to be made in a democratic system. But it doesn't matter what that law in itself said, it still adheres to the rule of law if it's made by making these steps. And then there's thinkers who are more substantive, if I remember correctly, that say it also has to promote equity, it also has to promote equality between people, it has to be good laws. And so you'll have seen the procedural versus substantive dichotomy before. But in this context, I think it's easier to think of it slightly differently. When we talk about a procedural rule under section 53, what they're talking about is the procedure by which it is shown to the court that a trust exists. And substantive rule is a rule that sets a standard to be met for the trust in itself to be valid. And I think you need to be thinking about how to define, there's lots of different definitions you could give to procedural and substantive. You need to find a definition that works for you and to really fix it in your mind. What does procedural versus substantive mean in this context, as opposed to jurisprudence? So procedural, we're talking about the evidence that is shown to a court about whether or not a trust exists, and substantive, we're talking about the steps that you need to take to make a trust valid. So that's the difference between them. Now, the first one we're going to talk about is section 531b, and this is a procedural rule. So it's not about whether or not the trust is valid, but what evidence a court will accept to accept that the trust exists. Section 531b is about the law of evidence. Now, I'm going to give you a very potted history lesson here. I'm not an expert. I don't know how true this is, but this is what was explained to me when I did trusts. Trusts at its core historical value actually came from soldiers going away from England to join in the Crusades. Now, the Crusades were, at a very basic level, a series of wars from about the 13th century. So Richard the Lionheart, sort of 1200s, in which Christendom in various Christian countries in Europe decided to wage war against various Arab nations, normally in Palestine, normally about who has control of the Holy Lands in Jerusalem. And various campaigns were launched throughout the centuries, normally with the backing of the Catholic Church, to try and take control of Jerusalem and the Holy Lands. They achieved very little other than to kill horribly and needlessly lots of innocent people, as wars tend to do. But the important thing about trust of the Crusades was that when these men, who were often called up to be soldiers, or they were on retainer, so that they fought for the knight or the baron or the lord or whoever they worked for, they would have to fight in the army, and that meant they had to leave their home. Now, this was an age before really reliable ships. Obviously, there weren't trains or planes, so they were basically marching across Europe and round Turkey and round Constantinople to get to these Holy Lands. It took a very, very long time, and they would be away for years. So they weren't just popping off to the local battlefield to fight for whichever king, they would probably be away from their home for years, and it wouldn't be clear whether or not they could come back, and they would have extremely limited communication with their families back home. And so it became legitimate to leave somebody in charge of your land or your home, or your farmstead. So maybe a friend or a relative or your wife or somebody gets permission to deal with these things in the way that you would deal with them if you were at home and not fighting in a crusade. And so that's where trust came from. But of course, with land, long before the Land Registry and the Land Registration Act in 2003, and now we have the Land Registry to evidence whether or not somebody owns land, you had to have the deeds to the land to prove that you owned it. And I'm using deed in the very old-fashioned sense of an actual sort of piece of paper that said, it didn't have to be signed by two witnesses, it was an actual piece of paper that said whoever holds this is the owner of the land, or so and so is the owner of the land, and it would list all the deeds and the covenants and the obligations that came with owning this piece of land. And if you could steal that, if a thief could steal that, then they might be able to say that they were owner of your land, but obviously people kept good care of their deeds. So there was a concern, and this was addressed way back in 1677, so hundreds of years ago, that instead of needing to get hold of the deeds, all you would need to do is say, well, so and so, when he left on his war, or he went abroad to Italy, or he, went off somewhere else, he said he would leave the land on trust for me, or he said that he was going to be trustee for me, and in that sense could defraud the landowner out of their land. And that was a real concern for the courts. And so they said, and this is a rule that continues to this day, that you need to have something in writing signed by the settler saying that this, I have indeed put this on trust for you or for the beneficiary. And this is to stop people just saying, well, so-and-so left it on trust for me and now it's mine. And for the poor settler who never meant to settle anything saying, well, no, I didn't. And then the court has to decide, well, which one was right. The important thing is that it doesn't say that you need to write down that you're going to give. You don't need to, when you separate your legal and your equitable ownership, you can do that. You might declare yourself trustee of the land and you might not write anything down, and it's still an operational trust. But if it ever came to a dispute about whether or not this had ever been put onto trust for you, the court is only going to accept something in writing. Something in writing saying, I did in fact hand over this trust. And it might be that you did it, you created the trust and then 2 years later you thought, oh, I better write that down. And so the trustee writes it 2 years later. And then 4 years later, the beneficiary says, oh, you're no longer acting as trustee, and they take them to court. That piece of paper that was written 2 years after the trust was created, that's fine as evidence. That can be used, and that evidence is the trust. It didn't have to be made at the time the trust was put into practice, and it didn't mean that the first 2 years of the trust it was invalid or inoperational. It doesn't mean anything. It just means the only thing the court will accept is something written that says this trust does exist. And that's why you have to look at the actual wording of 1b that said a declaration of trust respecting any land or any interest therein must be manifested and proved by some writing signed by some person who is able to declare trust, or by his will, and we'll talk about testamentary wills in a minute. But it manifested and proved, not it only comes into being when they sign this piece of paper, but when it comes before the law, it needs to be shown by a piece of paper. And the difficulty that the writers of the subject guide have, and this is what they've pointed out, is that sometimes the operation of this rule isn't necessarily sort of kept to. Ong and Ping is another case where the intention to settle the trust was proved not in a writing that was signed by the settlor, but from a photocopy of a document that suggested that this had been done, and some correspondence with a solicitor. And the authors of the subject guide say that wasn't rightly decided. Maybe that you find some academics who say that it was rightly decided, so you need to read that and think about how that would be argued. But what they're saying is that the operation of section 531b isn't, it is that there needs to be written, a certain type of written evidence that the trust was created, and not evidence of that there's something in writing of the trust being created. It's a tricky distinction. It wasn't enough to show, or they're saying that it shouldn't have been enough for the plaintiff in Ong and Ping to be able to say there is written evidence that something was put into writing. The evidence had to be the writing itself, and they're saying on this basis it was wrongly decided.